Hello everyone. Today, we're going to dive into one of the most fundamental concepts in Canadian corporate tax, how to determine a corporation's residency. It's the absolute first step in figuring out a company's tax obligations here in Canada.
Just a quick note before we jump in. All the material we're covering has been carefully prepared to give you a really clear and practical handle on this key tax principle.
To really understand this whole topic, we have to go back in time, way back to 1906. This quote from the famous British case of De Beers is everything. It established this powerful idea that a corporation's home, its residence, isn't just a mailing address on a legal document. It's where the real decisions get made. This concept is the absolute bedrock of what we now call factual residency.
So, here's our game plan for today. We'll start with that nuanced concept, factual residency and its CMC test. Then we'll look at a much more black and white rule called deemed residency. After that, we'll see what happens when those two ideas collide, creating dual residency. And finally, we'll wrap it all up with a practical analysis framework you can use.
All right, let's jump right into our first section, factual residency. This is where we have to look past the paperwork and find out where a company is truly, factually being run from.
So here's the crucial point. Under common law, a corporation is a resident where its central management and control, what we call CMC, is located. This is a question of fact. It doesn't matter where the company was incorporated or where its factories or stores are. What really matters is answering one question. Where is the highest level of control?
So what exactly is this central management and control? Well, the best way to think of it is as the corporation's brain. Now, we're not talking about the manager running a specific plant or the person in charge of a sales team. We're talking about the highest level, usually the board of directors, the people making the big, strategic decisions that set the entire company's course.
Okay, that makes sense. But this leads to a very practical question, especially today, right? In our globalized world, if the directors, the brain, are scattered all over the planet, how on earth do you pinpoint its location?
Let's use a classic example to really make this clear. Imagine a company that's incorporated in the Bahamas. Pretty common. It has a small board of directors, just 3 people. 2 of them live in Canada, and the third lives in the United States.
Now, let's look at scenario A. Let's say the board of directors physically gets together for their meetings in, say, Toronto. Well, those 2 Canadian directors make up a majority of the board. Because they are exercising their control from within Canada, the CMC is therefore in Canada. And just like that, this Bahamas corporation is a factual resident of Canada, meaning it's subject to Canadian tax on its worldwide income. But watch what happens if we change just one little fact. In scenario B, what if those same 2 Canadian directors hop on a plane and fly to the US for their board meetings? Well, the physical place where that control is being exercised has now moved. The CMC is now in the United States, and suddenly the corporation is no longer a factual resident of Canada. This really shows you how critical the physical location of that decision-making can be.
Okay, so that's the common law test. Now let's move on to our second section. Because while factual residency is based on, well, the facts, deemed residency is a straightforward black and white rule written right into our Income Tax Act.
Deemed residency basically gets rid of all that gray area of the CMC test. Under subsection 254 of the Act, the law just says, look, if certain conditions are met, a corporation is automatically deemed to be a Canadian resident. It doesn't matter where the brain is. All that matters is where and when the company was legally born.
Now, this rule hinges on one very important date, April 26, 1965. For any corporation incorporated in Canada after that date, the rule is incredibly simple. It's automatically a deemed resident, end of story. For older companies, those incorporated before that 1965 date, there's an extra hurdle. They are only deemed residents if, at some point after 1965, they also did business in Canada or were a factual resident here.
This, of course, brings us to a potential conflict, which is our third section, dual residency. What happens when a corporation looks like a resident under Canadian law and under the laws of another country at the exact same time?
So you can probably see where this is going. Let's think about a really common scenario. What happens when a company is incorporated in Canada after 1965, making it a deemed resident here, but its entire board lives and meets in the United States, making it a factual resident there? Which country gets to tax its global profits?
And there you have it. That's the classic dual residency problem.
The corporation is literally caught in the middle, with two different countries both having a legitimate legal claim on taxing its income. Our example is perfect. Deemed resident in Canada because of its birth certificate, but a factual resident in the US because that's where its brain is.
So, how do we solve this? Well, thankfully, we have international tax treaties. The Canada-US treaty has what's called a tiebreaker rule. For corporations, this rule is crystal clear. The company is treated as a resident only in the country where it was incorporated. So in our example, it's a resident of Canada. And our own Income Tax Act backs this up, with Section 255(5) then making it a non-resident of the other country. But, and this is a really important note, you have to be careful. This incorporation test is specific to the Canada-US treaty. Other treaties might use a different test like the effective place of management, which sounds a whole lot more like our original CMC test.
All right, we've covered a lot of ground. Factual residency, deemed residency, tiebreaker rules. So now, for our final section, let's pull it all together into a clear, systematic framework that you can actually use to figure this out.
Think of this as your roadmap, your checklist. If you follow these 5 steps, in this order, you can navigate the complexities we've discussed and come to a solid conclusion about any corporation's residency status.
Okay, let's walk through it. Step 1, you always start at home. Is there any reason this corporation is a Canadian resident? Is it a factual resident because its CMC is here, or a deemed resident because it was incorporated here? Step 2, now look abroad. Could it also be a resident of another country under their laws? If the answer is no, you're done. But if it's yes, you go to step 3. Check if Canada has a tax treaty with that other country. Step 4. If there is a treaty, you find and apply that specific tiebreaker rule. And finally, step 5. If that rule says the corporation is a resident of the other country, then it's officially deemed to be a non-resident of Canada for tax purposes.
And that brings us to a final, thought-provoking question. You know, this whole concept of central management and control was born in an age of physical boardrooms and face-to-face meetings. But what about today? In a world of remote work, Zoom board meetings, and globally scattered teams, how do we define where a company's brain truly is? This century-old idea might just become the biggest question in the next chapter of international tax. Thank you.